Okay. I'm going to call the committee to order. Everybody who is here, please vote aye.
We got 1, 2, 3, 4. You got enough? Madam Chair, you have a quorum.
Yeah, that's fine. Can we do proxies now?
Okay.
Committee will stand at ease for a little bit.
Okay.
If you needed any.
Okay.
I got 4 o'clock meeting.
Okay, we're going to be really quick. I'm going to have to turn it over to you in 1 minute because you're going to chair for 1 minute. Okay, I apologize. I think nearly every person is proxied out, so we're ready to go. I'm going to turn it over to Senator Chafin for just 1 minute because the first bill I'm going to just dispose of, it'll take less than a minute, and that is the governor's appointments, which is SJ 133, which I am carrying. So, Mr. Chair, there you go. I have SJ 133, and this is confirming the governor's appointment, which is the head of the Department of Elections. And I would make the motion that the committee pass the bill.
Is there a second to that vote? To that motion?
Second. All those in favor, please say aye. Aye. Cast your vote.
It's rough. Where's rough?
Clerk will record the vote.
Ayes 13, no 0.
Okay, the next section of bills we're going to take up are the constitutional amendments. And these have identical bills that were heard on our side. The first one is HJ 6, which is Delegate Mirez. And this one is the constitutional amendment, which is on second resolution. It's the real property tax exemption for surviving spouse of a disabled veteran. And I'm going to ask for a motion. And the motion is the motion's been made and properly seconded to report and re-refer to finance. All in favor, please vote aye. Okay.
Ayes 13, no 0.
And then the accompanying HB 71, which is the constitutional amendment, real property tax exemption language. Okay. The motion's been made and properly seconded to report HB 71 and re-refer to finance. All in favor, please vote aye.
Ayes 14, no 0.
Okay, and then the next one is Delegate LaRock's HJ 41. This is the constitutional amendment that's also on second reading, the transportation lockbox. It's identical to our SJ 35. I'd like to entertain a motion to report and re-refer to finance. Is there a motion? Motion's been made and properly seconded. All in favor, please vote aye.
Ayes 9, noes 5.
Okay, and then the accompanying HB 734. The motion is also to report and re-refer to finance.
Senator Vogel, there's a line amendment that we need to make to 734 before we send it to finance.
Okay. Meg, could you read the line amendment?
Sure. There was a drafting error. The standard date for when these constitutional amendments become effective is January 1st, 2019. So in lines 60 through 61, we're striking July 1st, 2018, and inserting January 1st, 2019.
Move the amendment.
Okay, the motion's been made and properly seconded to amend the language of HJ 734. All in favor, please say aye. Okay, now the amended version of HB 734 is properly before us. This is identical to our SB 400. The proper motion is to amend and re-refer, to report and re-refer to finance. All in favor, please vote aye.
Ayes 10, noes 4.
Okay. So that disposes of our identical bills, I apologize, constitutional amendments. And next we have up legislation, and I'm going to follow the sign-up sheet. And the first person on our sign-up sheet is Delegate Wilt. Good afternoon and welcome.
It requires that anyone that's collecting voter registrations, that on that registration, they would include their name, their telephone number, and an organization if they're working for one. The catalyst of this, Madam Chair, is a lot of times the registrars get misinformation, and through whatever the process is, wrong information gets passed on to them, and then they're charged with trying to figure it out. This is not voter suppression, not trying to hinder anyone's registration. It's simply trying to provide another tool that the registrars would have someone to contact that, maybe that they could get the right information from. It's no guarantee, just another possible tool.
Okay, is there any member of the committee who has a question of the patron? Senator Eben.
Just to clarify, or maybe for council, we already started this generally a few years ago by collecting, if you get more than 50 or something, you have to put the name of the person collecting. Is that accurate or no?
Madam Chair, Senator Eben, that's for certain sized organizations that collect a certain number of applications from the State Board or the Department of Elections. It's not for everybody.
Okay, Madam Chair.
Senator Eben.
I like the idea of making sure that when someone fills out an application, if the person assisting for them, that they don't get it wrong or wrong again, if they're giving them advice. But what would happen if I thought I applied and I got it wrong? Now is my registration not, I guess it's not valid now. This would help safeguard that process? Is that what's going to happen?
Madam Chair, Senator Eben, yes, this is simply another step in trying to get that information correct. It's not a guarantee. It's simply not. The person that's collecting the registration, they may not remember who it was. It's simply another tool, and maybe they have some way of positively identifying, getting that information correct.
And a final question, Madam Chair.
Senator Eben.
For council, maybe. So, if I understand this correctly, if I got the will to register to vote, and I did not fill that out, he would still be validly registered if he got the application right. Is that correct?
That is correct, Senator Eben.
Thank you. I would move to report at the appropriate time.
Okay, is there any member of the audience who wishes to speak in favor of the bill? And I think we have an about to motion to report, so.
I'm going to keep it short and sweet.
Okay,
Walt
great.
Latham,
Thank you.
Registrars Association President. Sorry for the minute. I had a late lunch. We are supportive of this bill because we would be concerned about voter suppression too. It's not our understanding that it would affect the registration of the voter. The concern we've had is getting forms that we have no way of tracking, you know, which person with an organization has done the paperwork on that voter's form. So, you know, it would be a way of trying to figure out if a voter is collecting, or if an organization or a person is collecting voter registrations at Food Line or Walmart or wherever, we would have a better chance of being able to track down who or what is making it harder for people to register to vote.
Thank you.
Okay, there was about to be motion. Senator Eben? Is there anybody, let me go back. Is there anybody in the audience who wishes to speak in opposition to the bill? Okay. Is there a motion?
Second.
Okay, the motion's been made and properly seconded to report HB 1144. All in favor, please vote aye.
Ayes 11, noes 3.
Bill reports.
Thank you, Madam Chair, committee members.
Okay, next on the list is Delegate Marshall. Okay, Delegate Marshall's not here. Next is Delegate LaRocque.
Thank you, Madam Chair.
Welcome.
House Bill 1167 relates to jury commissioners and registrars. We have a problem in some localities where DMV database information is used to generate jury questionnaires. From my own clerk of the court, I was informed that sometimes those questionnaires contain information, responses that would disqualify people from being jurors and would also disqualify them from voting, being able to vote legitimately. So we're just basically trying to facilitate the transfer of information from commissioners, sheriffs, others who collect that information to the registrars. We have an amendment that was brought at the request of the clerks just to address concerns. I think that we weren't creating too significant a mandate upon the clerk. So I believe that with this amendment, has that been distributed?
Okay, there's a line amendment on line 44 and line 45.
Move the amendment.
Amendment's been moved and seconded. All in favor of the amendment, please vote aye.
Aye.
Okay, now the amendment is properly before us, the amended bill. Is there any member of the committee who has a question of the patron? Is there anybody in the audience who wishes to speak in favor of the bill? Welcome.
Madam Chair, members of the committee, Tyler Craddock on behalf of the court clerks. We appreciate Delegate LaRocque working with us on this amendment, and with that amendment, that answered the concerns that we had and that he stated.
Thank you. Is there anybody who wishes to speak in opposition to the bill? Senator Eben,
Court clerks.
will you come back?
You mentioned that you like the amendment. Do you support the bill?
Our members are not taking a position. That's a policy choice for the committee to make on the bill.
Thank you.
Ours, yes, you're welcome.
Yes, ma'am.
I'd like to speak in favor of the bill, if I may.
Sure.
Clayburgh Wheeler, Vice Chairman of the Electoral Board, State Board of Elections. I've been a participant as a local electoral board member in trying to glean this information, and it is very helpful. And it's very helpful the way this bill has been constructed, because the transfer of information becomes more automatic and less time-consuming, and will help maintain good and accurate voting records. Thank you.
Senator Edwards.
Sure. I'm trying to figure out how this would actually work. You commissioners shall collect the information obtained from those persons not qualified to serve as a result of different categories. And then a general registrar should utilize the information. to identify persons no longer qualified, et cetera. How would you get all that information? I mean, wouldn't this be pretty burdensome?
The mechanics of this would, actually, I'll point to the amendment. It basically is permissive, and by amending line 44 to say that they may enter into an agreement with the general registrar for the locality. That, I think, again, gives the authorization, but does not require or necessitate that they act on that. So they shall collect, they may enter into an agreement to exchange, and then the last part of the bill instructs the registrars, if they receive the information, to use that to update the voter rolls.
Well, Mr. Chairman, what assurances are that the information is correct? Is there, I mean, you get information, but it's just information. It may or not be accurate. So you're basically disqualifying somebody to vote based on this information, aren't you?
Well, the jury questionnaire is something that would, I assume, be notarized or validated, and certainly be taken seriously.
Well, Mr. Chairman, you're not a lawyer, I guess. Anybody that's looked at jury information is just filling out forms that may or may not be right.
I know in the case of our registrar, Madam Chair, what this triggered is the registrar then, by mail, confirmed this information with the prospective voter to assure that it was true and accurate. I think asked that there be some validation, and all that took place before the voting rolls were adjusted to remove a name or to act on the information.
Anybody in the audience? Anybody else in the audience wish to speak? Any other members of the committee have a question?
Move to
Okay.
report. Second.
The motion's been made and properly seconded to report House Bill 1167 as amended. All in favor, please vote aye.
Ayes 8, no 6.
Thank you, Madam Chair.
Bill
Members of the
passes.
committee.
Thank you. Delegate Marshall? Still not here? Okay. Delegate Simon is next on the list. Welcome.
Madam Chairman, how are you?
I'm great. How are you?
Good. I've got two today. Do you have any preference in which?
Nope, you
one
can
we
take them up in
first?
whichever order you wish.
All right, I think I'll do the easy one first, which is House Bill 1424. As you all may remember, this fall, we had a very, very close election in the House in Newport News. It actually resulted in a tie, and there was a drawing of lots, and there was some question as to how to read the code after the drawing of lots. It seemed to indicate that the loser of the drawing of lots would be entitled to another recount, even though we just had a recount. I think most of us agreed that's not what we meant to say there, that if the tie is the result of a recount, then the drawing of lots is it, and you can always, obviously, go to the General Assembly for a challenge.
Can I interrupt you before you keep going? Because this is actually easy, and I mean no harm to your bill at all. But
I will stop talking, Madam Chairman.
we actually, as you may know, had a discussion with the registrars right at the beginning of the General Assembly session about a number of bills that were really critical that we pass and a number of subject areas that we knew we wanted to address. And we drew that subject area a little narrowly, but then we actually also expanded it to include this specific issue. And we have created a joint subcommittee of the House and Senate. And this was one of the bills that are one of the subject areas in which that falls. So I would like to make the recommendation, if you do not object, that we send this to that subcommittee, that it be discussed, and that we bring that back next year. And once we have agreed, because there were several different vehicles out there, we've agreed, you will be either the patron, chief patron, or the co-patron on the bill that passes when we make a decision.
Madam Chair, I don't suspect we're going to have another problem with this just next year. I think this is something that happens every 40 or 50 years. So I do kind of wonder, though, what other solution there might be for this one. This one, like I said, seems so straightforward. I think that's why in the House we'd like to just go ahead and go forward with this one. But I wouldn't oppose it if it's better than a no vote, and we can refer it, and that'd be the way to go.
So I'd just like to ask if this committee would be okay. We'll send it to the subcommittee. We'll work on it, and we'll come back with the opportunity to have everybody's input. Okay,
Madam Chair, I so move.
okay. The motion's been made and properly seconded. HB 1424 will go to our special sub, and with your input in the interim, we'll come back. Okay? Everybody in favor, please vote aye. Okay. Okay, next bill.
Next bill, House Bill 690. You all did a very similar bill, I think, for Senator Mason. They have a similar issue in Williamsburg. But this bill would have done, the approach that this bill takes is it says that if the locality has a population of 15,000 or less, the registrar need not live in the locality where they serve. We have a situation where we have a young registrar who came, and actually was young when he came to Falls Church to serve as registrar. He's sort of grown up in the community. His family's gotten bigger. He can't afford to live in the city of Falls Church anymore. He'd like to continue to serve. The city would like to continue to have him there. But he'd like to move out of town to a little lower cost of living area and commute to Falls Church to do it. I know that, like I said, that you all did something similar with Senator Mason's bill, which had a threshold of 25,000. I guess we could do it a couple ways. We could, I'd be happy with the line amendment that raised our 15 to 25, and that could keep the bills sort of in harmony with one another.
I love this idea. I'm hugely in favor of your bill. I think, so this is similar to Senate Bill, just to remind everybody on the committee, to Senate Bill 556, which was reported by this committee 8-5 and passed the Senate 36-4. So everybody seems to love this idea. And it allowed a person appointed to be a general registrar to be qualified voter of a city or county, or a county or a city adjoining city or county which he is appointed. So Meg, I think what we had decided is we were going to amend, let's see, we're going to conform HB 690 to our 556, and then we'll just work it out in conference. Is that okay?
Fair enough.
So someone make that motion?
I move that we conform Delegate Simon's bill to Senator Mason's bill.
Yeah. Okay. That motion's been made and properly seconded. All in favor, please vote aye. Okay. That's pretty easy.
All right, thank you, Madam
Thank you,
Chairman.
Delegate Simon. Okay. Delegate Cole. Welcome.
Thank you, Madam Chair. I have three bills. Let's start with one that I think should be relatively easy and I don't think is controversial. Famous last words there, but anyways, House Bill 28.
It's never how you think, right?
Yeah. House Bill 28. What it does is it corrects confusion in the code regarding when a voter registration list is due from the Department of Elections. There are two dates in the code, and so this just corrects it to make it one date.
And I think you have a line amendment.
We do have a line amendment to remove the potential for a felony charge being brought against the Commissioner of Elections. If council could report that.
Okay.
Madam Chair, on line 96, we'll strike all of line 96 through affirming on line 97 and insert the word certify. So the sentence will read, the Commissioner of Elections shall certify that the data included in the report is accurate and reliable.
Move the amendment.
Okay. The line amendment has been moved and seconded. All in favor, please say aye. Aye. Okay, now the amended bill is in front of us. Is there any member of the committee who has a question of the patron? Is there anybody in the audience who wishes to speak in favor of the bill? Is there anybody who wishes to speak in opposition of this bill that passed unanimously out of the House?
Second.
Okay. The motion's been made and properly seconded to report House Bill 28. All in favor, please vote aye. Okay, you were right about that.
All right, thank you. Next one is a bill you all have seen before. It's House Bill 158, and it just allows the General Assembly to make technical adjustments to legislative districts after a redistricting process solely for the purpose of reducing split precincts, and the change cannot be greater than the deviation that was approved during the redistricting process. I think this is is something that we have historically done after every redistricting, and I think this is probably the best approach to trying to reduce split precincts that were an issue in a couple of elections this past year.
I will just say from my part, as a member who has had my localities plead with me every time to introduce legislation that would address that issue, I am very supportive. I don't know if there any member of the committee who has a question, the patron.
Madam Chairman.
Senator Cosgrove.
Thank you, Madam Chairman. I'm also extremely supportive of this bill. The 14th Senate District has these little things look like little appendix. They come down, carve out one little street, in a neighborhood. And I think that Delegate Cole's bill here is probably an answer to that type of question. However, it was done because of the deviation requirements from the last redistricting. Some of that was bound to happen, but this is a good bill, and I think it's important.
Is there Senator Eben?
One I can't remember. Did we pass or did we refer to the commission the bill from Senator, the bill that would have dealt with making sure the precincts weren't split during the initial redistricting process?
I can say, Madam Chair, that we dealt with a Senate bill to deal with that. It was a little different approach in House P&E subcommittee this morning.
Did you pass that fine bill?
Yeah, I think we
So,
did.
Adam, I tried to be very consistent with everything that we sent to the sub. So anything that so in other words, so that the committees were matching up. Yeah.
I'm not suggesting go to the sub. I was just curious what happened the other.
Okay, sorry.
But I did have a point, which is that when we do the redistricting, at that point, we have the opportunity to not split precincts up front. And I wish that we would deal with it that way rather than tinker in between and tell people that they were in a precinct, but they moved for the very next election. That's my personal preference.
If I may respond to that.
Sure.
The problem is that we have two different bodies doing things at the same time. We're responsible, and this would be true whether if we had an independent redistricting commission or not. We're responsible for doing legislative and congressional districts, while localities are responsible for doing their own districts and setting precinct boundaries. And those efforts are going on at the same time. So we don't know how precincts shift. Actually, our legislative redistricting is done based on the old precincts, and that's why, and then the localities end up moving precinct lines, and that's how you end up with a significant number of split precincts.
Madam Chair?
Senator Edwards.
I'm sympathetic, but the other way to do it is let the localities revise their precincts after we do the legislative districts. Every 10 years. Yeah,
but either way, I mean, somebody's going to have to make changes after the redistricting process. And localities, because I was in 2000 and 2001, I was on the Board of Supervisors when we were going through redistricting. And localities are careful to try to make sure their districts don't split precincts. All right, so that's how they draw their precinct lines, is to line up with their local districts, Board of Supervisors, City Council, or whatever. So that as they're changing their districts, they're also changing their precinct lines. And so, you're either going to end up with split precincts at the legislative level or split precincts at the local level if you try to force the local governments to not split precincts based on legislative districts. If they're not going to split precincts at the local level, they would have to move their magisterial district boundaries to match those precinct changes.
Well, Ms. Chairman.
Senator Edwards.
I think one of the issues, the potential for mischief, to be blunt about it, on the part of the General Assembly.
I understand those concerns, believe me, I do. And right now, there is nothing in the code or the Constitution that would prevent that mischief. If you pass this legislation, it would put limits on it that you could only do it for, to reduce split precincts, and you couldn't change a district more than the deviation that was used during redistricting. Right now, there is no limits on how you can change districts in the interim.
Mr. Chairman, Madam Chair, well, other than the constitutional thing is you can only do legislative districts every 10 years.
There is no, in the Constitution or in the code, there is no, nothing that says you can't do it in the interim.
Other than the Constitution?
No, it doesn't.
Well, every 10 years is what it says.
Yeah, it says you do it every 10 years, but it doesn't say you can't do it every year.
I guess there's a dispute among lawyers about that, maybe.
Okay, Senator Chafin.
Madam Chair, Delegate Cole, so I've got this little island in the New River that is between Radford and Montgomery County. It's actually Montgomery County. There are 2 houses and 3 people. I voted 100% of that island, of those people. But that comes at a pretty good cost to Montgomery County. I have 3 people in Montgomery County, unless somebody's moved in or out since I last walked it. And I think that's what this gets at, is little ridiculous situations that cost the public money. So I'll be moving to report.
Is there anybody in the audience who wishes to speak in favor of the bill? Please come forward.
Good afternoon, Madam Chair and members of the committee. I'm Katie Boyle with the Virginia Association of Counties. We have some language in our legislative program in favor of unsplitting precincts, and so we would support efforts to minimize precinct splits during redistricting, and I plan to encourage my members to work very closely with the General Assembly during the next round of redistricting to avoid splits on the front end. And we also support this as a tool to clean up some of the technical errors and mistakes that may have happened during the course of redistricting, because sometimes it is easier to fix the split by moving the state line than the local line. Thank you.
Okay, is there anybody who wishes to speak in opposition to the bill?
Good afternoon, Madam Chair, members of the committee. Lauren Schmidt on behalf of the administration. We do oppose the bill. We have questions about the constitutionality, as Senator Edwards brought up. Thank you.
Yes, Senator Ruff.
I have 27 split precincts spread across 5 counties. Those counties have to pick up the cost of having duplicate people and machines in those precincts. Is that fair and right?
Madam Chair, Senator Ruff, I can't comment on the policy of that. I will say that the administration supports Senator Obenshain's legislation that would prohibit split precincts, SB 983, which I believe this committee passed out. So we do agree it's an issue and understand the concern, but we do feel that the Constitution is very clear that redistricting is done in 2011 and every 10 years after. And so that's where the questions of the constitutionality come in.
But historically, nobody ever questioned the constitutionality of changing those precincts. That occurred the next year or the year after for years.
Madam Chair, Senator Ruff, I cannot comment on that. I'm not familiar with that.
I did.
Thank you.
Okay.
Madam Chair, my voice can be asked one more time.
Yes, Senator Cosgrove.
You know, the nebulous constitutional issue, I think, is really not based in fact. Now, I am not an attorney. Like my good friend and shipmate here, we're engineers. We get black and white. And this is definitely a black and white issue. Or green and red, pick your color, it doesn't matter. But this is a solution to a problem that has been plaguing elections, and especially was evident in the last election. Delegate Cole is here to try to fix a problem that exists right now and not have to wait every 10 years to fix something that's messed up. So I'm going to give a resounding second to my friend from Russell, to his motion.
Okay, so motion's been made and properly seconded that we report House Bill 158. All in favor, please vote aye.
Ayes 8, nays 6.
Okay, bill reports.
Thank you. My last bill today is House Bill 1325, and it deals with split precincts, but it simply says that if your voter is in a split precinct and he thinks that he's been given the wrong ballot to cast in that split precinct, that he would be given a provisional ballot, and then the electoral board would determine which one to count, after the fact. This again is brought in response to some of the issues that we saw in the last election, where actually a few voters in my area actually did say, no, you're giving us the wrong ballot, and it turns out they were right. So again, this is just to try to make sure that people are voting in the correct district. I have been contacted by some of the registrars who don't like the bill. It will cause, I think, a little bit more work for them on election day, but I think it's worth it to try to make sure we got people voting in the correct district.
My recommendation to the committee was going to be that because it falls in the category of a possible solution, that might be a part of a larger discussion that we could work through during the subcommittee, that we send this to the subcommittee. So if you guys would make that, if that's okay with you, Mark. Yes. Yes, Senator Sproul.
Code, but this
We
also
are
have,
sending, right.
sorry, but this also have the problem we have up in state, where the Speaker of the House from.
That was what I was
Right.
referring to during my testimony, because I represent Fredericksburg as well. And we did have a couple of voters in Fredericksburg who were the registrar had them voting in one district when they were actually in another district, and they brought it to the attention of the election officials on election day, and they said, sorry, you got to vote. And it turns out they were right.
Thank you so much.
So I would like to have a motion to send this to the special subcommittee that will meet during the intervening time between this session and next session, to have all the stakeholders have an opportunity to sit down and consider what is the absolute best recommendation for next session for how to deal with this issue.
So move.
Okay. Motion's been made and properly seconded to send House Bill 1325 to our special subcommittee that's going to address this issue. All in favor, please vote aye.
Ayes 13, noes 1.
Thank you, Delegate Cole.
Madam Chairman?
Yes,
Before
Senator
Delegate-
Cosgrove.
Before Delegate Cole leaves, I'd ask the question, does Delegate Cole have any input into who sits on that?
Yes, he does.
Thank you.
He has a whole lot of input. Thank you, Delegate Cole. Okay, next is Delegate Ranson. Welcome. This bill has not generated any discussion at all this session.
Not really. Not much at all. Madam Chair, members of the committee, I have House Bill 1405, a similar
Okay.
bill, I think.
Okay, I'm just going to, just for purposes of giving the committee some background, this bill started out as a bill that was identical to the bill that Senator Edwards brought to this committee. And you all may remember that at the beginning of session, this may have been the first or second bill that this committee heard. And it was when Senator Edwards was sick and Senator Deeds did such a bang-up job presenting the bill that we had actually unanimous support for it before we got a little further down the path, and then we kind of didn't. So I have had some conversations with Delegate Ranson, and I know this bill's been worked on the House side. I think that in all of my time in the Senate of Virginia, I have not heard anybody more appreciated than Senator Edwards was during the course of his heroic effort on this bill. He stood at the podium, and for those of you who weren't here, he might have been thanked close to 500 times for his hard work on this bill. And then he got out with something a little mushier than what he started with, but he stuck it out. So what I would like to ask Delegate Ranson to do is maybe just explain the bill a little bit. And I think there are a lot of advocates who are here who are incredibly supportive of what it is you are attempting to do, but might want to perhaps take it back to the original bill. So if you want to just make the presentation and describe it a little bit, and then we'll hear from them.
So my House bill is a little different from the Senate bill. My House bill has 3 members of the Democratic Party. It has 3 members of the Republican Party. Everyone is appointed by the governor, so we still have a lot of participation from the administration. The governor makes those appointments. They have staggering terms. The board would then appoint the commissioner. And it was really interesting when I was presenting this bill on the House side, we actually had so much participation from people from all over the state. One citizen stood up and said, listen, when the governor is making these appointments, could we put in the bill that he's given consideration to geographical location? So we went back and we amended the bill to make sure that the governor was giving consideration to geographical locations. I'm bringing this bill forward, and I believe the senator is too, out of good intent. I think we can all say that over the past 3 years, there have been a lot of problems within the commission, the commissioner, and the state board. I just want to make sure that the registrars feel comfortable again, that the voting process is comfortable, and our election process is moving forward in a good way so that our voters are confident in the process. The registrars work hard, and I want to make sure that they're getting the right answers back down in a good manner. And that's the only reason that we're bringing this forward. So I'm happy to work with the senator, and I'm thankful that he continued to push forward. I believe, like I said on the floor, that the governor wants to do things the right way. So I hope that we will continue forward with some sort of mechanism and bill. I just don't want anything to stop. So.
Okay. Is there anybody in the audience who wishes to speak on this subject on behalf of this bill?
Madam Chairman,
Yes, Senator Cosgrove.
before we take any action, I just want to say how much I appreciate Delegate Ransom and the hard work she's done on this. And I hope that everybody out there shows the same love for Delegate Ransom that we have.
I don't
for
think that's
Senator
possible.
Edwards.
It will.
Don't
I'm
love
just
me.
not
I
sure
mean,
that's
love the registrars. I mean, they've been through a lot.
Oh,
They've
no,
been
no,
through a
I'm
lot.
serious. You should have heard the Love Fest the other day. I just
Yeah.
want to make sure you got the same.
You missed what Senator Edwards got, so it's a little
Okay.
tongue in cheek because it was a little over the top. He got a lot of love and support. Yeah, Senator Edmund.
Also love Delegate Ransom, especially when her subcommittee passed my bill this morning. But I just want to mention, if this goes to a conference committee to both Senator Edwards and Delegate Ransom, the one thing I never understood is if you have the governor appoint people of the opposite party, and we don't really have party registration, but we know they're the opposite party, it might make sense to consider having the opposite party in the House and the opposite party in the Senate leaders consider appointing 2 of them and the governor appointing the 3rd. I don't know if that's a big deal. I know that one year we didn't confirm, I think, one of the governor's nominees of one party. Just a thought how that's determined. But I do like the bill, and I do love the bill, and I do love both Senator Edwards.
There's so
and
much
Ransom.
love in
There's a lot of love on the Senate side. You can't imagine. You just can't imagine. Okay. Okay, Senator Cosgrove, give us a motion, and then I want to hear some from folks in the audience.
I would move that we conform Delegate Ransom's bill to Senator Edwards' bill.
Okay. As introduced.
As introduced.
Okay. So the motion that Senator Cosgrove has made is to conform your bill to Senator Edwards' bill as introduced, but not as amended. And what I think that will give us is the original vehicle that we started with in the beginning. And I've actually talked to the governor's office and let them know that we were going to do that, to take it back to Senator Edwards' really original bill that was the result of I don't know how long the work group worked to produce that bill, but that would give us the work group vehicle, and that would give us the Senator Edwards vehicle, and then we could work through conference. And my commitment was to make sure we work with the governor's office and we'd get to a place where we don't kill this bill, but we give it the best life it's got and create, I think, the best opportunity that the stakeholders would be most pleased with.
Madam Chair,
Mm-hmm.
I want to second that motion, and just to assure that there's an opportunity for everybody to hug it out, okay, on this issue and try to get it worked out. Everybody's working really hard. I agree with that, and it's such an important matter to all of us, to everyone who works in the political process, that the public has an idea that there is not that we're keeping politics out of that office.
Madam Chair?
Yeah, the motion's been made and properly seconded. Senator Edwards.
Could we hear from the governor's office on this? Because this is the bill that I originally put in that the governor's office did not like at all. And that's why we came up with the bill that finally passed out of the Senate. And so the motion to go back to the original bill and not the substitute that passed out of the Senate, correct?
Right. So we'd go back to the original bill, but I will say the governor liked it at one time. He actually voted for it once.
Well,
and we're still having discussions with the governor on that subject because he loved it at one point.
And it takes away the governor's right to do the appointing. So I'd like to hear from the governor's office about this process.
Madam Chair, Lauren Schmidt, on behalf of the administration, Senator Edwards portrayed this correctly. We support the substitute of Senator Edwards' bill that was passed out of this committee and passed the Senate. We do not support the original version or Delegate Ranson's version because it does remove the governor's authority to appoint the commissioner. But I do want to be clear that we very much appreciate working with you and Delegate Ranson, Senator Edwards. I know everyone has the same end goal, and we very much want to protect the integrity of our elections, but we do have an issue with that one component.
Okay.
Thank you.
Mr. Chairman.
Senator Edwards.
Comment. Routinely, both houses just adopt what they passed originally, and then it's put in conference, if you want to put it in conference. But my bill got out of Delegate Ransom's committee this morning, 5-1. I don't know what's going to happen beyond that, but I would object to going back to the original bill. We've worked through this here in the Senate, in this committee, and the Senate. I think my bill passed the Senate 38-2. The House can do what they want. And if there's a difference between the two, it can be put in conference. But I think it'd be inappropriate at this time to go back to a bill which we know the governor is not going to support. He'd probably veto it if it ever gets that far. So I would make a substitute bill motion that we report that we conform the current bill to my original bill that passed this committee and the Senate. My final bill.
Second.
Okay. The substitute motion is to go back to his final bill, and that's been moved and properly seconded. All in favor of, to adopt the substitute. So all in favor, please vote aye. Yeah. There are some people who want to speak on that, and I think they will want to speak to that specific subject. But I don't know if we can actually debate that. Is that debatable? It is debatable? Can we hear testimony on that? Okay. All right. So I'm going to then ask the members of the audience who are subject matter experts to be clear for everybody on the committee. What we are discussing is the difference between the bill as introduced and then the bill as amended is whether or not the agency, well, you go ahead and speak to it. You can tell the difference between the two. It's whether or not the governor can appoint the agency head.
Madam Chair.
Senator Peake.
Yes, thank you. So the difference is whether the governor can appoint the agency chair, and then where do we stand as far as motions?
So the motion that is before us now that we are about to vote on after we hear their testimony to the specific point is the substitute motion, which is to report out the bill that was reported by the Senate, which is Senator Edwards' bill, that is the bill supported by the governor that allows the governor to appoint the agency head.
And so that is
not the original bill that the stakeholders asked for before.
Thank you.
And that Senator Edwards originally introduced. Okay, Walt. Right.
Walt Latham, President of the Registrars Association. We do like the original bill because we like, again, not to cast aspersions on anyone in the process, but just for appearance's sake and for a good government perspective, we just believe that the administration of elections should appear to the public. And I've heard people talk about how hard we work. We do work incredibly hard. But it's really about making sure the system works and we're able to do our jobs, but also that the public has confidence at the end of the day that the administration of elections is as far removed from the daily political process as much as possible. And that's why we like that. And I know there's been a push to have a 6-member board. The Registrars Association is firmly in favor of a 5-member board because of the ability to break a deadlock. The experiences we've seen during just while y'all are in session of 2 federal government shutdowns has led us to question whether or not the introduction of brinksmanship as a policy is really a wise one to pursue. So we like the 5-member board, and we like the idea of the commissioner not serving at the pleasure of the governor.
Senator Sproul.
We have, not to you, sir. We have heard this before. I thought we were looking at the original versus substitute. So they're talking about stuff we have already hashed before. They're talking about the same stuff over and over again. We have already heard all of that. I thought we were trying to determine whether or not the original bill versus the substitute. But they're talking about stuff we have already heard. So I don't see why we're doing that all over again. We have already heard all of that.
Well, the reason that we're hearing them speak to that question is because we're about to vote on whether or not we're going to do the original or the substitute, and it's specific to that question. Okay. Please come forward.
Robin Lynn speaking on behalf of the Virginia Electoral Board Association, somebody who's also deeply admiring of the delegate from Warsaw, who has worked certainly as hard as the distinguished senator from Roanoke. We originally supported the original version. We came to respect Senator Edwards' position that to have a reform that the governor would support was better than having no reform at all, because reform is desperately needed. And we would like the members of this committee to do what they can for us that would survive. Thank you.
Madam Chair, members of the committee, Cameron Sassnet, speaking on behalf of the Voter Registrars Association. One of the most disappointing things in government that I have seen in the past year was a meeting of the State Board of Elections held this past July. If you had seen that meeting or been part of it, you would have recognized that the most dysfunctional thing that had ever happened in the last year, 3 years, or even possibly 10 years, was the fact that the Commissioner of Elections and the Deputy Commissioner were disrespectful to the board at that meeting, and then further and further, to the point where the chairman of the State Board of Elections has had to ask, do I need to FOIA my own agency for information regarding things that he should easily be able to get? The accountability of the Commissioner of Elections should be to the people who are administering the elections, not to the people who are elected. It's that simple. And so I would like to point out that in 2010, and while things do change over the course of 8 years, a number of members of this committee, while in the House, I believe voted for a similar bill to what Senator Edwards had actually originally introduced. I believe, ironically enough, when it crossed over to the House side, it ultimately died with an opposing vote from Senator Edwards, interestingly enough. But the now governor actually voted for the bill. That was a 5-member board. Very similar to State Corporation Commission, making sure that the accountability of the people who run the people's business is out of the business of politics and in the business of what it's supposed to be. So I fully support, I know a lot of the members of the Voter Registrars Association fully support as well, the accountability that is instilled in the board overseeing and having authority over the Commissioner of Elections. So I would support the conforming, and I do apologize, Senator, I know it puts you in a hard spot, but I think ultimately that's going to be the best thing to ensure that the elections are run fairly and accurately in the Commonwealth. Thank you.
Senator Evan. Oh, Senator Sproul, you're first.
Chair, I heard what the gentleman was saying as far as being fair by having a nonpartisan, but I believe, Madam Chair, the last time this came before us, gentleman spoke, and I asked every member of the registered office, they are appointed by politicians. And they take Chesapeake, the rest of the board. We have two Democrats and one Republican. They are Democrats. We appoint them. If they were Republicans, we were not going to report them because it's our pick. So when you try to say they have the registered office not political, yes, they are. Every last one. Every last one. They are. I asked the same question when the gentleman came up last. I asked him, I said, you were appointed by Republicans. You were appointed by Democrats. So how can those same folks who are appointed by me not be political? I would not have, I'm not asking no questions, sir, no questions. I would not have appointed a person on the board who was a Democrat. Those 2 seats that we got, they would have never gotten that board if I knew that they were Republican. So, and vice versa, Democrats. I understand that. So the heartburn, I'm trying to get to the point as far as the register not being political. They are political. They are political. They're appointed by their parties. Thank you.
Others that wish to speak to the motion? Ms. Wheeler.
Thank you. Clara Wheeler, current Vice Chairman of the State Board of Elections, and I can echo that last July was a low point in elections in Virginia. It's been a low point for the last 4 years, elections in Virginia. And at the risk of fawning, I want to tell you that I have the greatest admiration for Delegate Ransom and her bill, because she's got the courage to stand up and defend what is right, not what everybody likes, not what is self-serving, not what is a power grab, but what is right. A bipartisan, 6-member State Board of Elections will give you bipartisan and as close as you're going to get to nonpartisan, which is what I think we all want to have in the operation of elections. To Senator Spurl, this would give you equal representation of Ds and Rs. That board, through a supermajority, that means 5 of the 6 members, would vote to appoint a commissioner who is answerable to the board, not to anyone else. Her bill is a good bill for the voters of Virginia. It is something we should want to achieve in a bipartisan construct, which is what we want, so that we don't have one party or the other ruling the roost. It should be equal and bipartisan. And so I stand to support Delegate Ransom's Bill 1405. It may not be the pleasure of this committee, but I would like to thank you for being strong. Thank you.
Are there any other individuals that wish to speak? All right. So the motion that is before you, for point of clarification, the motion that's before you, if committee members like the original bill of Delegate Ransom, they would vote no. If they like the bill, the governor's bill, they would vote yes.
Okay. Okay, the substitute motion is before us. That was Senator Edwards' substitute motion, which was not to accept the original of 825 as originally introduced by Senator Edwards, but instead to conform to your amended version. So if you're in favor of the amended version of Edwards' bill, you're going to vote aye. If you're not, and you'd like to go back to the original 825, you're going to vote nay. Okay? So all in favor, vote aye.
Ayes 6, noes 8.
Okay. So now we have HB 1405 before us.
Move to report. All right.
Okay. So now we need to conform. Okay, so now now we need a motion to conform HB 1405. That's the motion we do.
introduced version of it.
Yes.
I believe my motion was to conform.
Right, we're going back to the original motion. I apologize. The original motion to conform to the introduced version of Senate Bill 825.
I second that.
All in favor, please vote aye.
Ayes 12, noes 2.
Okay. So now we have HB 1405 before us. Is there any other discussion? Are there any members of the committee who have any further questions of the patron? Okay.
Second.
Motion's been made and properly seconded to report HB 1405. All in favor, please vote aye.
Ayes 12, noes 2.
Both reports. And again, I appreciate everybody. And Senator Edwards, you have my commitment. We have these two vehicles before us. We will do everything we can to make you very happy.
Madam Chair, thank
Delegate
you,
Ransom.
members of the committee.
Thank you for everything. Thank you, thank you.
And I intend to do that as well. Thank you.
Okay, thank you. Okay. Next on the list is Delegate Keem.
Thank you, Madam Chair, members. And for the record, I love Delegate Ranson. I think she's done a great job.
I don't know if you have the love on your side that we have on our side, though.
Yeah.
I couldn't possibly have lived up to our last meeting for Senator Edwards.
Thank you, and I appreciate all of you for being here. House Bill 397 was trying to address an issue that was brought to my attention by a constituent of mine from this last election cycle. I rarely ever vote absentee because I like to vote in person on election day, so I didn't realize that this was a problem until somebody brought this up. Turns out that if you vote in person on election day, you show up, you show your ID, you show your voter registration, you confirm that your address is where you live. They give you a little card, you go in, you vote, and you're done. If you vote by absentee by mail, you mail your application in, they send it back, you fill it out, and at that point you fill out your Social Security number, the last four Social Security number, along with other information. You mail that in, and then you get your application, the ballot back, you fill that up, and then you mail it. If you vote absentee in person, so if you show up before the election in person, not by mail, and then you're filling out the form, because the rule of the absentee ballot requires the last four digits of your Social Security number to be shown, even if you're in person, you're required to write that down. My constituent pointed out the fact that she and her husband had been victims of ID theft in the past. They just don't like to put any numbers down. And in the context where they were sitting in front of the registrar, she showed her passport, her driver's license, her voter registration, everything, and she still was required to put the four numbers down. She refused to do so because of ID theft, and as a result, she was not able to vote. So she basically said, it doesn't make sense when I'm standing in front of that person. So that's really what the bill would do, is to amend the language that says the application needs to have four digits numbers, unless if you're voting in person on absentee, just as if you're voting on election day, you wouldn't be showing that. So that's really what the bill does. Happy to answer any questions.
Okay, is there any member of the committee who has a question of the patron? Is there any member of the audience who wishes to speak in favor of the bill? Is there anybody who wishes to speak in opposition to the bill? Don't everybody stampede the podium at the same time. Okay. Senator Cosgrove.
Thank you, Madam Chairman. Delegate Keene.
Sure.
I just don't think it's that onerous of a responsibility to put down the last four of your Social Security number. We have to do that for all kinds of different things. And if the voter elects not to do that, then that is their option to elect not to do that. I know that, when we get our petition signed to run for office, we don't have to put down the last four of our Social Security number, but it sure makes it a lot easier on the registrars to be able to check off those signatures as being valid. I don't think it's an onerous imposition, and unfortunately, I'm not going to be able to support your bill.
Thank you, Madam Chair.
Yes, Senator Deeds.
Second.
Okay, the motion's been made and properly seconded to report. Yes, Senator Cosgrove. Okay, substitute motion?
That would be to PBI the bill.
Okay, substitute motion is to pass the bill by indefinitely. All in favor of passing HB 397 by indefinitely, please vote aye.
It's PBI.
Ayes 7, noes 7.
Okay. So now we need to go back to the original motion, which is to report the bill. All in favor of reporting the bill, please vote aye. I think it's okay.
Ayes 10, noes 4.
Thank you, Delegate Key.
Thank you, Madam Chair. Thank you, Senator.
Okay. Next on our list, Delegate Jones.
Good afternoon, Madam Chairman and members of the committee. I've got two bills. Which one would you like to take first? Does it matter?
You can decide.
Okay. I will do House Bill 767, since it's the lower number. This is a bill that's done every 10 years. I think they actually just took the language from 10 years ago and changed the dates on it, which will say, beginning next year, that your jurisdictions will not be able to change their VTDs or precinct lines so they can start participating in PL. I'll mess it up, Janet. I forget the data, but there's data that's collected for the Census Bureau, so it's frozen, so they'll be able to collect the data, and it'll be GIS mapped properly.
Right, and just for members of the committee for background, this is our sort of standard precinct freeze bill that we cannot live without, cannot survive without. This bill is similar but not identical to Senator Obenshain and Senator Barker's bill, which is Senate Bill 983, that this committee embraced warmly. And so I think what we would like to do is basically conform this bill to Senate Bill 983.
So moved.
Okay?
Second.
Motion's been made and properly seconded to conform it to Senate Bill 983. All in favor, please vote aye.
What's one more conference committee?
Took the words out of my mouth. Probably about 15 on Saturday.
Yes, you can certainly ask a question.
Sure. For Delegate Jones, I just want to understand, I support the concept, but I was wondering if they change the precincts to fit the districts that were split, if that's something that this would prevent. I don't think Obenshain's bill prevented that.
They will have the opportunity, as I understand it, until February of next year to make changes. Once you get to February, the beginning of next year, then you have to freeze it because the data we have to submit to the Census Bureau and to those that are working in that space of doing all the, I guess, working with the GIS and the mapping to make sure the census blocks and data is properly inputted.
Okay, so this is just for the period while we're redistricting to make
Right.
it easier. Got
And
it.
just
Thank you.
Senator Eben, for background, we do this every time. Senator Howell carried this in 2008. This is like the Obenshain Barker bill, only that one was a little broader. Right.
You might have been
Okay.
here too long when you had a bill from 10 years ago that's got your name on it, you're still here, so.
Still kicking and still passing.
That was directed at me, Your Honor, not to anyone else.
Okay, is there a motion?
I would move to report the amendment.
Okay, Senator Cosgrove moves, and Senator Chafin seconds that we pass HB 767. All in favor, please vote aye. Okay, bill passes unanimously.
Madam Chairman,
Next.
House Bill 1598 deals with the criteria for our congressional and state districts. It would be effective after the next census in 2020. I believe the difference from the Senate Bill 106 that was passed and is in the House was just in the enactment clause number 2. This was a bill that I actually put in and drafted myself, so it wasn't artfully as drawn as it could have been. So staff was very helpful in wordsmithing it so it looked a lot better when it left the chamber.
And Madam Chair, we actually cleaned up the enactment clause in SB 106 as well, so these bills are now identical.
Okay, so if we pass this
Excellent.
bill, we want to pass it as is.
So we both needed help. Okay.
Madam
Senator
Chair,
Howell.
Does this, I haven't had a chance to read it, but does this include the deviation percent? We had different ones, the House and Senate last time.
It speaks to, it doesn't give a percentage, it speaks to how you would handle that. You would be allowed to have some deviation, but this would say as nearly as practicable. I have a hard time with that word. We talked about compactness, contiguity, communities of interest. So we put this into the code because before, when we did it 8-9 years ago, Senator Howe, we had differing criteria, and this puts it in the code for the first time in that regard.
So,
Senator Howell.
so the goal is to have the same criteria for the House and Senate
Well, this.
of this bill, the goal of this
Well,
bill?
the goal is that we would have criteria for when we, as a General Assembly, go to draw the lines. We would have what I would call guidance from the Code of Virginia as to how we would deal with the issue of court cases that have been before the U.S. and state courts, respecting existing political boundaries, how you would treat compactness and contiguity, and then how you would deal with communities of interest where Senator Cosgrove and I represent, he doesn't represent that particular part, but we've got 3 cities that come together, and we call it Tri-Cities area. So you might want to have them together because it's Churchland, Western Branch, and North Suffolk. So that would make sense to not honor those political boundaries, but to have a communities of interest. And so I think this speaks to that. It does not speak to the political nature of drawing lines. There are court cases that are going on now that I feel will be instructive to us when we get to the process in 2020 of how we would approach that.
Madam Chairman. Madam Chairman.
Oh, sorry, Senator Cosgrove.
I'd move to report the bill.
Mr. Chairman, I have a question.
Yes, Senator Edwards.
Now, this is identical to Senator Sutherland's bill, right?
Yes, sir, as I understand it.
If you look at line 27, it says existing political boundaries should be respected to the maximum extent possible. That's, would you not agree, that's a greater extent than any of the other factors here?
I would not say that, no. I'm not an attorney, but I would not interpret that.
Well, nothing else says maximum. It says these other ones should be considered, like composed of compact districts, communities of interest, contiguous territories and population and so forth. But this is the only sentence that says maximum extent possible, right?
Correct, but if you look at lines 16 through 22, we're actually driven by the, when you look at congressional, they need to be, equal. And so that would override that, in my opinion, to that extent, Senator Edwards.
But if you look at this D, it says existing political boundaries shall be respected to the maximum extent possible. Political boundaries should include the boundaries of counties, cities, towns, county, ministerial districts, et cetera. These are local government boundaries that are already there, right?
I think the key word is 2, 3 before that, respected to the maximum extent possible.
Well, it says existing political boundaries should be respected, yes, to the maximum. What does maximum extent possible mean?
Madam Chair, I would say to the gentleman, when you look at some of the districts that have been drawn in the past, some have opined that you could have done a better job considering keeping cities and counties whole. Well, so this makes it clear, if I can finish my remarks. And so this was language that was in a bill that was presented several years ago that I thought was proper to put into this legislation. But if you'd like, you can strike the maximum extent possible, and I would consider that a friendly amendment if you think one supersedes the other. This was to give those individuals who feel like we have not respected those community lines to the extent, so it says to the maximum extent possible. It doesn't say you shall, they shall be quote unquote above and beyond all the other redistricting criteria.
Well, that would be improvement. On line 27, put a period after respected and delete to the maximum extent possible.
No, I would say this shall be
Senator Edwards, I'm just going to interrupt for 1 minute, if I may, and say this is just language that we have used. It's redistricting language that's been consistently used with all the pieces of legislation that we've introduced. It was in my legislation. It was in the criteria bill that Senator Lucas and Senator Howell, and it's been followed by language that actually gives a little wiggle room, and it says, if a departure from existing political boundaries is necessary in order to comply with other districting criteria, the district lines shall be drawn utilizing clearly observable physical boundaries. And it goes on to say, so I'm just clarifying that so that you understand that it does allow a lot of wiggle room, and it's more just a descriptive.
Madam Chair, I disagree. I'd make a motion, then put a period after respected, delete to the maximum extent possible. And the reason for this is these local government boundaries existed way before one person, one vote was required by the Supreme Court. And you cannot mathematically do what you want to do with the existing lines without really creating a mess. It's just, I'm not sure it's mathematically possible, given the fact that the legislative and political congressional lines have got to be within a certain degree of the same, of equal. And to do, and then given the fact that the Commonwealth has grown so much, these localities are, the numbers are changing all the time. I don't think it's possible to actually to do it to the maximum extent possible. These are factors to be considered, yeah, but not to override any other factor. Therefore, that's why I make that motion to make that amendment.
Madam Chair, all I would say is, for example, we had, when we did the House districts, we didn't have a split in one precinct in Chesapeake. The city went back and split that, and I ended up having part of a split precinct because they did that when they drew their lines for their local. So, you know, it's almost like we're chasing our tail, and we can have example after example, I believe, of where we feel something hasn't been respected.
Right.
The design behind this bill was very plainly to take the criteria from the last two cycles, try to put in the code of how we would be guided when we get out, when we get to 2021, after the census is performed in 2020.
Yeah. Mr. Chairman, Madam Chairman.
Senator Edwards.
Would you not agree? I mean, it's a chicken and the egg thing. If after we do ours, then the localities can redo theirs too, like to avoid split precincts, for example.
All right, well, let me ask this first. Is there anybody in the audience who wishes to speak in favor of the bill? Here we go. This is what we need.
Okay. Madam Chair, Jim Turpin, 1 Virginia, 2021. We support the bill in principle. We would like to have seen it gone further, particularly with regard to political gerrymandering, but we do believe it's a step forward in setting criteria for the future. Thank you.
Do you have anything to add or any observations to make to the point that Senator Edwards is making about that language, about watering that down or removing that language?
I'd rather not go there.
Okay. I thought you might say that. Is there anybody else who wishes to speak in favor of the bill? Is there anybody in the audience who hates redistricting criteria and would like to speak in opposition to the bill?
Madam Chairman.
Senator Cosgrove.
I hope that we'll resist these amendments that have been offered. You know, we already passed out Senate Bill 106. This bill is identical in its form now. Granted, people here, you know, some liked it, some didn't. But to kind of tinker it around and put Chairman Jones yet another conference, I think we just ought to go ahead and pass the bill.
He's got nothing but time. I mean, come on.
Pass Bill
Nothing but time.
106.
I got a motion pending.
Right, okay, so Senator Edwards made the motion to remove the language. That's okay. Is there a second? Okay, the motion's been made and properly seconded. Meg, do you want to read the words that he wants to take out? To the maximum?
To the maximum extent possible.
To the maximum
Put a
extent
period
possible.
after respected on line 27.
Okay, so period after the word respected, and then remove the words to the maximum extent possible. All in favor of that line amendment, please vote aye.
Oh, sorry about that. Fancy machine.
Ayes 5, noes 9.
Okay, the line amendment is not adopted, so now we're back
Madam
to
Chairman,
Senator
I'm-
Cosgrove's motion,
Yeah,
which is to report House Bill 1598.
I second.
Saves you another conference.
Thank you.
All in favor, please vote aye.
Ayes 10, noes 4.
Bill reports.
Thank you very much. I appreciate
Thank
the
you.
time of the committee.
Thank you. Delegate Marshall. Okay. This was going to be our last meeting of the Privileges and Elections Committee, but we have HB 591, which is Delegate Hugo's bill. And, oh, it's HB 1210. Sorry, 591 was a Senate bill. HB 1210, which I believe he has requested to go back for the week. Did that happen? Okay. So can someone make that motion and go back, that bill go back for the week? That's been made and properly seconded. All in favor, please say aye. Aye. And then we've lost Delegate Marshall. So his will have to go back for the week. Okay? Okay. Okay, so with that, the committee shall rise.